She's a San Diego native. She attended University of San Diego, where she graduated magna cum laude with a bachelor's degree in political science. She knew she wanted to be an attorney, and Heidi began working in law offices at the tender age of 14. After she graduated from USD, she went on to obtain her Juris Doctorate from California Western School of Law, graduating in the top third of her class. During her time as a law student, Heidi concentrated her law studies in the areas of estate planning, tax planning, and corporate business law. She's been serving as an estate attorney for some 18 years now, and she is RA's select professional partner for all of our legal presentations for over 15 years. Welcome, Heidi Klippel.
Well, thank you, Suzanne, so much for that nice introduction. And thanks everybody for being here today to be part of this educational presentation, which sadly covers a very unfortunate topic, which is elder abuse. So unfortunately, elder abuse is the #1 crime in the United States, which just makes me so sad. So today we're going to talk about different types of elder abuse, signs that you can look for so that you can help advocate for a loved one, the different agencies that you can report these crimes to. And then we'll also be talking about some common legal, what am I trying to say? Sorry. Ways that people abuse people through legal means with elder abuse, in addition to talking about the scams that are out there and are prevalent today that impact our elderly population. So unfortunately, the statistics show, as I mentioned earlier, that elder abuse is the #1 crime in the United States. And generally speaking, it's our elder population that has dementia or any kind of a disability that is the most susceptible to this type of crime. To be categorized as elder abuse, the victim must be 65 years of age or older. And unfortunately, oftentimes they say elder abuse, despite being the #1 crime in the United States, is also the most underreported crime in the United States. And part of that is because our senior population doesn't always know what resources are available to them. In addition, they're not always aware of who the appropriate authority is to contact to report the abuse. And unfortunately, elder abuse is most commonly committed by a victim's family members and loved ones. And for those reasons, oftentimes that abuse also goes unreported, because the victim is afraid that if they report the abuse, they might get cut off by a family member. Oftentimes the family member committing the abuse might be the very family member who's driving the person to their doctor's visits or to their CPA's office, or just helping them with their day-to-day activities. So sometimes the abuse is not reported because the victim is dependent upon the individual that's committing the abuse. So the statistics are really sad. The statistics are 1 out of 10 Americans do suffer from elder abuse, and that out of 14 cases of elder abuse, only 1 out of 14 cases is actually reported, and that 90% of these incidents are committed by a family member, which is really unfortunate. So you've got different types of abuse. You've got physical abuse, you have emotional abuse. Common signs of physical abuse include untimely or unexplained death, infected bed sores or pressure ulcers, unexpected falls, unexplained injuries like broken bones and sprains, head injuries, bruises, arms, cuts, or abrasions, medication errors or overdoses, malnutrition and dehydration, unsanitary or unclean conditions. Sometimes you can also see signs of physical abuse by signs of broken eyeglasses or eyeglass frames. Sometimes you can also see abuse by bruises on a person's wrists if they're being restrained. And then sadly, you also have the situation which our firm deals with often, is when a caregiver is refusing to allow the family to come see a person in their care. In addition, you also can have people threatening to abuse a loved one. You also have emotional abuse. Sometimes signs of emotional abuse can be shown by the victim if they're agitated or if they withdraw, if they are frequently crying, if they complain of being treated poorly, if they have unusual weight loss, malnutrition, dehydration, if their living conditions are kind of bad, if there's dirt or bugs or soiled bedding or clothes, that can also be a sign of emotional abuse and or self-neglect. Sometimes, unfortunately, I've had situations where people are in assisted living and a loved one knows that their loved one is not getting bathed properly and getting the adequate day-to-day care as far as, having help to the toilet. That unfortunately is more common than it should be. You also can have financial abuse, which is what I'm mainly going to be talking about today. You also can have healthcare fraud. Sometimes loved ones do commit healthcare fraud by trying to have billing be over excessive so they can get the reimbursement. You've got over medication. I, unfortunately, from my own personal experience, had a family member who shall remain nameless, who was taking the pills of another family member that was in their care. And when the family member who was being prescribed the medication passed away, we found in the caregiver's personal effects pills and prescription bottles from the decedent relative. So unfortunately, medication abuse also is a common form of abuse, which the sad thing about that is oftentimes the person who needs the medication isn't getting the proper medication, so they can be in unnecessary pain, which again, that can be shown by signs of agitation. You've also got, as I mentioned, the financial exploitation, which is what we're going to talk about. You've got the misuse of a person's personal checks, credit cards, or accounts. We tend to get a lot of calls about that. You've got a family member or caregiver stealing money, using checks, or it's stealing household goods. We've also had a lot of calls about that. You can see a sign of a problem if a person suddenly experiences a significant change in their financial situation. Again, missing items can be indicative that there is abuse. Unfortunately, I know way too well that you can have sudden and spontaneous changes in a person's estate planning documents, title to their vehicles. We'll talk more about that during this presentation. You've got financial activity that is kind of out of the norm and spontaneous. And then sometimes you can also identify financial abuse if there's an increase in unnecessary goods or deliveries that weren't something that was being ordered or delivered previously. And then you've got the scams that we'll talk about. There's some charity scams that are done on the phone. There's investment fraud scams. There's the prize scam. And there's also that scam where a loved one gets called and told that their grandchild has been kidnapped and they need money for bail. So there's a lot of scams out there, unfortunately, but let's talk about the financial side of this. So when I have seen in my own law practice situations where I had a client that I had a very close relationship with because she was very astute about coming in on an annual basis and having a face-to-face meeting to talk about her family dynamic, her legal documents, and she always wanted to make sure that she was on top of having all of her legal and financial affairs in the right order. She unfortunately had a family dynamic where she had two children. One child was very responsible and very helpful and very caring. The other child, unfortunately, had some serious addiction issues, and that child had stolen from her, sold her jewelry, and they had a pretty estranged relationship. So through the years, I learned about this family dynamic through her estate planning documents. We planned for this family dynamic. And thankfully, I always took really good notes during all these meetings. So she had 2 kids, a son and a daughter. The son was the apple of her eye. The daughter was unfortunately the one that was going through a difficult time with her addiction issues. So I had a meeting on calendar where the daughter was coming in with my client, which was the first time I'd ever met the daughter, because in all the previous years I'd met with this client, I was told that the daughter was really kind of not in the picture, and due to the estrangement, not really involved in her day-to-day life. So during this particular meeting, my client comes in and the daughter immediately started nervous talking, the type of talking where she's talking super quickly and she seems to be a little flustered because she's trying to make sure that she remembers all the things that she wants to say. She's not really taking her time and communicating. She's talking super quickly. She's a little breathless. And basically what she told me was that her mom wanted to update her estate plan and that her brother had a serious drug issue, which I knew from my notes that that wasn't the case, and that her mom wanted to change her estate plan to disinherit her brother and to give her the entire estate. So I looked at her and I said, well, thank you so much for bringing me up to speed. So then I looked at my client and I said, now I need you to tell me in your own words why you're here. So she, without missing a beat, pulls a piece of paper out of her pocket and she starts reading to me a letter that basically said that her son had a serious drug addiction and that she wanted to disinherit him and she wanted to put her daughter in charge of her financial affairs effective immediately, in addition to disowning her son. So then I asked my client, I said, do you mind if I look at that piece of paper? And she said, no, not at all. So then I took the paper out of her hand and I looked at my client again and I asked her, I said, do you mind just telling me one more time in your own words why you're here? And she kind of paused for a minute and she looked around the office and she kind of gathered her thoughts and she took a couple of minutes to do this. And then without missing a beat, she looked at me and she says, so who are you again? So, and unfortunately, I've had that situation happen multiple times, which is really unfortunate. And my duty is to my client as the attorney. So I looked at her daughter and I said, look, I just want you to know that, I've got a relationship with your mom. I pretty much know that everything you've just told me is incorrect. I said, so what you should really be doing based on what I've just seen occur is it looks like it's time for mom to go into assisted living or to have some in-home health care. And luckily I had her son's phone number, so I was able to reach out to him just to make sure that mom was getting the proper care that she needed. But the good thing about the legal side of this is, as an attorney, I can only update a person's estate plan if a person has capacity or if the documents give permission to a third party to update the estate plan. So as a practitioner, when I draft estate plans, I never include powers of amendment to a third party because to me, the power to amend an estate plan is personal to the owner of the assets and shouldn't be extended to a third party. So my estate planning documents never include those powers, and it's for reasons like this, because they can be abused. So the nice thing about our laws in California is we do have specific laws in place that say when a person loses capacity, which due to the statistics, that's when elder abuse is most likely to happen, that person legally is unable to update their estate plan. And that's for good reason, because oftentimes the person is unaware of what they're trying to do and why they're trying to do it, which is why the law doesn't allow them to do it. So, and that's in that example that I just explained, it was, really sad to see this woman's daughter bring her here into the office on the pretense that mom wanted to basically disown her son that through the years was always her go-to person, and really took care for her and advocated for her. So situations like that do happen. I've seen them here multiple times occur. Another situation that I've seen is a similar situation where I'll get a call from a bank officer or representative saying that somebody is sitting there with their adult child who's not on the account and doesn't have any authority on the account. And they're not 100% clear that the person who owns the account is really wanting to make a withdrawal, but the third party, which is usually the adult child, is directing the bank to go ahead and make a large withdrawal on behalf of the person whose account it is who's not able to communicate. So luckily, financial institutions are very on top of these types of things, usually, but not always. Sometimes if you don't have a relationship with a teller or person in the bank, they may not know that, somebody's coming in to try to take monies from your account. I know a situation where there was a client of mine who was on life support. She was in a permanent vegetative state. And the entire time that she was on life support, her adult daughter, who was kind of her failure to launch child, who moved in with mom. And the deal was the failure to launch child could live with mom as long as she took mom to her to the doctor, to the hospital visits. And then mom in turn would do all of daughter's grocery or laundry. She would cook her dinner. And the daughter at the time was in her mid 60s. Mom was in her mid 80s. And that duo, I don't think it worked very well, because I know from other family members that the daughter was sheltering her mom, not letting family come and visit. And usually those are pretty big red warning signs that elder abuse is occurring. One of the family members was able to get some time one-on-one with her mom outside of the sister being present, and mom did tell her that her daughter was isolating her, but she was fearful to tell anybody in the family because her daughter had threatened to cut off all communication with the family, in addition to threatening her mom that she would no longer help her get to the doctors and help her figure out her medications. And unfortunately, the difficult thing in a situation like that, which these statistics show, is oftentimes people will tolerate the abuse because they feel dependent upon the very person who's abusing them. And in this situation, what occurred is mom ended up being taken off of life support. And when her eldest son was the trustee administering the estate, he saw that for the 2.5 months that his mom was on life support, in a permanent vegetative state, in a coma, in a hospital, not able to talk, not able to open her eyes, not able to walk, not able to leave the hospital, every single day that her mom was in the hospital, in ICU, in a coma, the daughter that was living with mom was using mom's bank card to go to the bank and taking out the maximum withdrawal on a daily basis for 2.5 months. So we figured out that during that 2.5-month period, daughter had taken around $17,000 out of her mom's bank accounts, but those bank accounts were titled in her mom's individual name, and the daughter was not the mom's durable power of attorney or the mom's trustee. So legally, she had no power to be taking those monies out of that account. But she did know where her mom's ATM card was, and she did know what her mom's codes were. So I called the bank and explained the situation to them. And the bank basically said, go to the police department, file a police report, get us a copy of the police report, which we did, which was super easy to do, by the way. I went with my client because he was pretty shaken up by all of this. And so we went to the police department. He filed the police report. We got a copy of the police report. We then in turn gave a copy to the bank. And without blinking an eye, the bank within a 48-hour period credited back to that account that $17,000. So the bank was super easy to work with. And it was the credit union in Point Loma. So shouts out to that bank because they were super incredible to work with. And then I called the district attorney's office on behalf of the trustee because he was interested in finding out whether or not the district attorney's office would pursue a criminal investigation of the matter, because he wanted his sister to go to jail for elder abuse and fraud. So I talked to District Attorney Paul Greenwood, who is truly the salt of the earth, most kind human being on the planet. And he asked me how much monies were taken, and I told him it was around $17,000. And he asked me about the circumstances in which the monies were taken, and I explained that the victim was in a coma, she was in ICU, she was in a vegetative state and unable to take the monies, that the account was in her individual name, and that the daughter was not a co-owner, not a co-signer. And then the district attorney explained to me that because the amount of money that was withdrawn was so insignificant, it really didn't make sense from a cost benefit analysis for the county to be involved and to pursue a criminal investigation, because the cost of that investigation would have cost the county around $100,000. So I was honestly pretty surprised by that. I'm not a criminal attorney, so that's not my everyday wheelhouse, but I was surprised to find out that even though a crime had been committed, it was a crime that didn't involve enough money for the county to get involved in. But those are the most prevalent types of situations I've seen as an estate planning attorney. I've also seen situations where person will put an adult child on title to their property. I don't quite understand why people do that, because legally that's not the best way of holding title. And then it gets to a point down the road where mom or dad who own the property needs to go into assisted living. And as a lot of us know who have loved ones that have gone into assisted living without the benefit of long-term health care insurance or other medical insurance that will help cover that cost, long-term health care and assisted living or in-home health care services, if you need it on a 24-hour period for somebody who has diminished capacity or has diminishing capacity, is a very expensive proposition. So, sorry, just lost my train of thought. So this particular client wanted to, so there were two kids. One kid, the failure to launch child, was on title to the property, and the non-failure to launch child, who was basically trying to advocate for mom or dad. I don't remember if it was the mom or dad in this situation, but basically wanted to list the property for sale to create a bucket of money so that there would be enough liquid monies to pay for this assisted living and in-home healthcare for the remainder of their parents' lifetime. But the failure to launch kid refused and said, I will not sign off on a deed. And because I'm on the deed, you need my signature to be able to sell the house without going through a court process. And unfortunately, in that situation, the house sat. The sibling that wanted to put mom or dad into assisted living ended up paying out of their own pocket to have somebody come into the house and take care of mom and dad. And then when mom or dad died, that sibling was unfortunately unable to get paid back because there was nothing in the trust that anticipated that situation. So the trustee wasn't able legally to give that beneficiary a larger share of the estate as a reimbursement. So that is also unfortunately a common thing that I see. I had a client who had a husband who had Parkinson's and needed some assistance around the house just for a couple of hours a day so that wife could go to the grocery store and do errands. And she hired a person to come into the home from an agency and basically just needed between 2 to 4 hours on a daily basis to be able to leave the house and know that her husband was in good care should he need to use the restroom or if he needed food or to be given his medication. So she, long story short, was talking to this caregiver, and the caregiver revealed to her that she got paid, I think at the time, $12 an hour. And the gal that was paying her was really taken aback by that because that on an hourly basis for this in-home healthcare provider to come into her home and provide these services. So she was paying the company around $25 an hour, and in turn, the company was paying the caregiver around $12 an hour. This was probably 10 or 15 years ago. So what my client decided to do is she decided that she would hire this person under the table. This person quit her job. My client paid her a higher salary and had her work more hours, which she thought was a win-win for both of them. And then a couple of months later, she discovered that this care provider was taking her checks and writing a check here and there for $1,000, $500, $600. And by the time my client figured this out, there was about $75,000 in checks that had been written from this person to herself for various things. So she calls the caregiver upset, wanting an explanation. The caregiver, unbeknownst to her, lived in Tijuana, and she just didn't show back up to work. So my client calls me and says, I want to sue this agency. I want to get my money back. And I asked her, when you hired this caregiver from this agency, did you by chance sign a contract with them? And she said, I sure did. And I said, can you send me a copy of the contract? Which she did. And in the contract, there's a clause that says, if you want to hire one of our caregivers who we have placed with you from our agency and have them work for you directly, there's a finder's fee that you have to pay our company. Well, she didn't pay the finder's fee and didn't follow the contractual terms of the contract. So I had the unfortunate job of explaining to her that if she tried to sue the agency because of the monies that the caregiver stole, they in turn could sue her for breach of contract because she didn't technically follow the terms of the contract and how she hired this individual. So I've heard of situations like that occurring with multiple clients, which is unfortunate. I've been practicing law for about 20 years now. So in 20 years of practicing, I've heard situations like that come up at least 20 different times. So one of the things I'd love to caution all of you about, if you have a loved one, whether it's a mom, a dad, brother or sister, or a close family member or friend, when it comes to hiring people to come into your home, you have to be very careful when you do that. One of the benefits of hiring an agency and paying those higher fees is that agency is using their resources to do a criminal background. They're also paying that person unemployment, Social Security, and all the things that you're legally required to pay an employee as an employer under the employment laws of California. So what another scam that's happening in the state of California that's pretty prevalent right now is people will hire family members, friends, or even people that they don't know to come into a home and to be a full-time caregiver for a loved one. And what they do is they make an arrangement where they won't charge that person rent to live in the house, but that person is working a longer day than an 8-hour day, but the employer isn't paying them over the table. So they're not paying that person's Social Security benefits. They're not paying into unemployment. They're not paying into all of the things that legally an employer is required to pay. And so what happens is because they're paying this person under the table to save on all of those taxes, what is happening in at least in San Diego, the common scam here in our county is the person who's living in that property will fake a slip and fall on the premises of the property. So now the owner of the property is liable because this person is acting like they were injured on the premises. And then when the person tells them, I don't think you were really injured, I think you're scamming me, the person says, well, that's fine. I'll just report you to the IRS and I'll let the IRS know that I'm working longer than an 8-hour day and you're not paying me overtime. You're not giving me sick time. You're not even correctly paying me as far as my unemployment, Social Security, Medi-Cal, and all the things that employers require to do. And then they basically hold the person for ransom and say, pay me X amount of money and I'll go away. So it's, in my opinion, it's always better if you're going to bring a third party into a home to be a caregiver. You do want to go through an agency because you want somebody to come into the house who's been vetted. You want the criminal background check to have occurred. You want to make sure that that person is being paid properly under our California employee statutes as far as overtime, sick time, paying into the Social Security. Because if you pay somebody under the table, that's technically illegal. So you're committing a crime. So that's a common scheme in our county and one that should be avoided. Another thing that happened to a client of mine is he had an aunt who lived in another county here in California. She had no spouse, no kids, and him and his sister, her nephew and niece, were her two closest living relatives. And she had an estate plan that put them in place of making her financial decisions if she lost capacity. So he called me concerned saying, Heidi, I need you to do me a favor. My aunt's got this problem. She lives in another county. She's got a lot of money and she keeps playing the sweepstakes. And I guess the way the sweepstakes approach this is the more money she spends on buying things, they make it seem like the more likely her chances of winning these sweepstakes will be. So she keeps paying and paying and paying into all these different sweepstake scams, and she won't listen to us. She won't listen to reason. So then I had to ask him, does your aunt have capacity? And a common response to that is, what does that mean? So I said, if your aunt has the wherewithal to know why she's spending the money and what the money's being spent on, and understands the difference to spending the money and not, then she has capacity. And he says, yeah, my aunt's fully lucid. She knows what she's doing. She knows why she's spending the money, but they're tricking her, and that's not right. So I wanted to take over her financial affairs. And I get asked this question a lot. And what happens is, in the state of California, when you have a loved one who isn't making, in your opinion, the best financial decisions, you can't just arbitrarily come in and take over their financial affairs, because that is a constitutional right to be in charge of an individual's own financial affairs. So the only way that you could legally take over a person's financial affairs is, one, if they voluntarily resign as a trustee or durable power of attorney and ask you to come on and take that over, that is when you can legally take over a person's financial affairs. If they have the capacity and want you to come on, they could either stay on and be a co-trustee acting with you, or they can step down and they could resign as the trustee, which by default would make you the sole acting trustee. Or if a person doesn't have an estate plan, or even, let me back up, if a person has an estate plan, but if they are incapacitated, most estate plans have language that once their doctor diagnoses that they lack the financial ability to make financial decisions, that's the triggering point where they lose the ability to manage their financial affairs. And that's when these documents allow a third party to come in and take over the management of the financial affairs. But if a person doesn't have an estate plan, there is no durable power of attorney, there is no trust. The way that a third party gets appointed to manage a person's financial affairs is through a court process called a conservatorship. So in the situation where a person believes that a person isn't making good financial decisions, in the state of California, as long as you're lucid and have capacity, you are allowed to make bad financial decisions. So this individual that I was talking to about his aunt wasn't very happy that legally there was no recourse for him to be able to come in and take over his aunt's finances, even though he didn't think the sweepstakes were the best use of her money. Because she had capacity, even though it probably was a scam, she was legally allowed to make those bad decisions. And that is one area of the law that's kind of gray, kind of black and white, because who can make financial decisions? What are deemed good financial decisions as opposed to bad financial decisions is a little subjective. And that's why the courts don't get involved. So it is always a good idea in California to have these legal documents in place that put people that you know and trust that can come in and manage your financial affairs, so that if you start losing capacity and want to bring them on to take over the management or teach them how to manage your assets, you will be protected as long as you're naming the right people to assume those roles. And if you don't have an estate plan, it's a good idea to create one, because once you start losing your capacity, when a doctor believes that you no longer have capacity to make financial decisions, you lose the ability to put these documents in place. So that is a piece of advice I always give to clients. If they have a loved one who has a diagnosis of diminishing capacity, or if a client of mine has a similar diagnosis of diminishing capacity, that window of time to put an estate plan in place or to review it and update it starts to shorten. And once that window closes, you're then before the courts, which can be costly, expensive, and public. And people do audit those public files. So that's another reason you want to avoid court, is you really don't want it to be public knowledge that a loved one has diminishing capacity, because that's just a gold mine for these individuals to, go and look through the files, look through the conservatorship files, see who's being conserved and why. And these sweepstake companies and scam artists know exactly who to focus on as far as their next victim. So that's an important thing to understand, is that these estate planning documents is a vehicle to help alleviate elder abuse by having these documents in place and by naming the right people that can be your advocate when you lack the capacity to do that for yourself. I had a client call who had that scam happen where they must have somehow called a couple of times and asked a couple of questions to his daughter, and they were able to put together a voice recording of his daughter saying that she'd been kidnapped, that she needed help, and that she was going to put them on the phone. And then a person came on the phone and basically said, don't hang up, don't call the police. We can see your cell phone. We can see what you're doing on your cell phone. You need to go to the bank right now and take out $100,000, and you're going to deliver it to this PO box. Otherwise, you'll never see your daughter again. And this guy is in his late 50s, fully lucid, scared out of his mind, had an inkling that it could be a scam, but was more concerned for his daughter's safety. So these scams that are occurring right now in the United States are so sophisticated that sometimes it's hard to know when it is a scam versus when it's not a scam. But for our parents and our grandparents and for the senior population, the more prevalent scam right now is the phone call where somebody says that they've kidnapped the granddaughter or grandson of the person that they're calling, and that they don't want to upset that person's adult child, the mother or father of the grandchild. So if they would go, and it's usually going to a store and getting a gift card or wiring, those tend to be the two vehicles that they try to get the funds. And that's how they're getting a lot of money out of our seniors, is by this grandchild scheme of calling and saying that they've got a grandchild who's been put in jail or who's been kidnapped. So, you know, it's tricky because you need your loved ones to have a phone, but oftentimes it's the phone and the mail, which is how these predators get access to our loved ones. So, you know, they're luckily cell phones now are pretty good. If you have a number programmed into the phone, their name comes up. Whereas if it's a number that's not programmed into the phone, it probably is a solicitor or it could be a scam. So if you're able to teach your loved ones about how to read the phone and how to only answer phone calls from people's names who show up that they recognize, that's one really great way of protecting your loved ones. I will say probably the best advice I give clients when it comes to this issue is all of us have the ability at any time during our lives to step down as our own financial advocates. So if I were 85 years old and if I had a diagnosis of dementia, and if I got to a stage of the dementia where I knew I had less lucid moments than more, one of the most important things that a person can do while they have lucidity is to invite that person who they've named in their estate plan as their successor trustee to come on board and to start acting with them as a co-trustee. Because if I'm 85 and if my capacity has been starting to diminish, and if I'm at a place where I'm confused and I'm aware that I'm confused and day-to-day tasks are very daunting, if I was comfortable, it would be very important for me to bring on that successor trustee while I still have capacity, and to teach them about my finances and to teach them about what bills I have, how do I pay my bills, when do I pay my bills, what are my logins, what are my passwords, so that if I wanted to resign as a trustee, I could always turn all of those financial powers over to a third party that I trust. And then I don't have to be worried about getting scammed, about making bad financial decisions, or being forgetful. Maybe I pay the property taxes on a Monday and then I forget by Wednesday that I paid them on Monday, and on Wednesday I send another check for the same bill. So I know it's something that most of us don't want to wrap our head around, and I can certainly understand, but having somebody come on and start helping you so that you can teach them about your assets and what your assets look like, and then having the courage and bravery to step down as a trustee is one way to protect your financial assets. Because if you're no longer in charge of your assets, it's less likely that you will fall prey to some of these scams because you don't have access to those monies. And that's usually what the creditors are looking for, is the monies. The trickier situation is family. I had a couple who had 3 kids, and all throughout our engagement, I knew that their youngest son was a little difficult for them. They felt he was abusive. He was the kind of son, in their words, that would only come around when he needed something, and the something was usually money. They always had their estate where he was specifically prohibited from being a trustee. They didn't want to put him in charge. They didn't ever want him making medical decisions. Well, long story short, the wife sadly lost capacity and she ended up going into assisted living. The husband still had capacity, and he had a fiduciary who was helping him with errands and his day to day, getting around places, banking, things like that. And it got to the point where it was so difficult for him to go visit his wife, because when she was not lucid, it was difficult for him because she didn't recognize him or remember who he was. And that was a very difficult emotional experience for him. And then other times when she was lucid, she would scream and hit him because she wanted him to take her with him. She didn't want to stay there. She didn't understand why she was there. So the whole situation was starting to take a real toll on his health. So the fiduciary that was helping him with his errands had recommended, because she was also a social worker, that he maybe stop visiting her as often. Well, what ended up happening is the youngest son started visiting mom out of the clear blue, when before he wasn't really involved in either of their lives. And then he called us wanting a copy of her estate plan, but I already had it in my file that she didn't have capacity. And because she didn't have capacity, I would need her husband to tell me to give him a copy of the estate plan. So I called him, I explained the situation. I asked him if he wanted me to share the documents, pretty much knowing his answer would be no, and it was. And then the son started calling our office every day for about 3 months, threatening to take us to court, threatening to sue us. And he was so malicious that we finally threatened to get a restraining order against him because he wouldn't stop calling our office and harassing us. It was horrible. So it was kind of an interesting twist being on that side of a very aggressive family member. And unfortunately, that's what people that are, dealing with elder abuse are dealing with. They're typically dealing with a family member that's very abusive, that's very pushy, that's very quid pro quo. If I'll do this for you, but only if you do this for me. I have had people make comments to me that when an estate plan is updated right before a person dies, it's automatically null and void. That's not factually correct. So if a person does update their estate plan and change it before they pass away, it's not automatically null and void if the person who's updating their estate plan has the capacity and wherewithal to understand the changes that they're making to an estate plan. Now, for us, as a matter of practice, we tend to not want to update people's estate plans when they're in the hospital or undergoing any kind of medication, because capacity could be challenged in those situations. But I have seen last minute estate planning where a person might have 3 kids and last minute they decide to give it to one. In the state of California, that's all legal as long as there's no undue influence and as long as the person has capacity. So in some of these family situations where there is the failure to launch kid, and maybe they do get mom or dad or grandma or their best friend to the attorney and these documents are updated, as long as that person understands what they were doing and as long as it's of their free will and it's not an undue influence situation, those changes and those estate planning documents are enforceable in a court of law. I know that when my own grandmother passed away, my uncle, who was the trustee, was given a bill from an estate planning attorney in town. So I called this attorney and I said, I'm the attorney representing my uncle for my grandmother's estate, and I have this invoice for an estate plan. I said, what is this invoice for? And she said, well, your grandmother was in the process of updating her estate plan. And I said, well, I noticed on this invoice that it's dated in whatever month it was, let's say November. I said, but my grandmother was in ICU in a coma in November on life support in a permanent vegetative state. She wasn't able to communicate with any of us, and I was at the hospital every day. I said, I find it hard to believe that my grandmother called you in November to talk about updating her estate plan. And the attorney said, "Oh, you're right. I just checked my file and it was your aunt that called about updating your grandma's estate plan." I said, "And what did my aunt ask you to do?" And she says, "Well, your aunt explained that your grandmother had 4 kids and that your grandmother wanted to give her all of the estate and put her in charge as the trustee." I said, "Well, unfortunately, my grandmother did die, and her estate plan that she did while she has capacity gives the estate plan equally to the 4 kids and puts her oldest son in charge as the trustee." I said, "So because my aunt called you to update my grandmother's estate plan," I said, "did you ever speak to my grandmother about her estate plan and these changes?" And the attorney said, "No, I did not." And I said, "Well, I hope you can understand I'm not going to direct the trustee to pay this bill, because as far as I'm concerned, the person who incurred the expense is my aunt, not my grandma." So those situations occur too, and they happen in my family. So, I mean, they happen every day, they happen all the time. So I think the best advice I can give everybody as far as how can you protect your loved ones, and I know this seems so simple and it's total common sense, is you have to be involved. You have to be proactive. You have to be visiting your family member at the hospital. You have to be asking questions about their capacity, asking questions about their medication, make sure that their medication and the dosages are being administered correctly and properly. I had a client tell me the other day that he was out visiting his mom at her assisted living, and one of the nurses there on staff made reference to the extra medication drawer. And he said, "What's the extra medication drawer?" And the nurse joked and said, "Oh, well, that's all the medication that people are prescribed that we're supposed to give that we don't think they need, so we stick them in the drawer." I couldn't believe it. So stuff happens. It happens here in San Diego. When it comes to assisted living, there's a lot of really incredible places here in San Diego where loved ones can be. And again, my best advice is to be present and to be active. You want to visit your loved one, you want to visit unannounced. You want to tour these facilities unannounced. The facilities hate that. They don't want you to come unannounced, but that's when you go. You don't want them to know you're coming. You don't want them to have an opportunity to give you a you want to just have them come and walk you through the everyday so you can see what it's really like. You want to go, you want to taste the food. You want to visit unexpectedly and taste the food. You want to see who's giving the medications, what's their protocol for medications, what happens if a situation occurs, what hospital do they call, does your loved one's insurance cover care at that hospital? You've got to review the medical insurance coverages. You've got to make sure that the facility has the healthcare directive and the durable power of attorney and the phone numbers of the people that should be called should there be an emergency or any questions needed to be answered. It takes so much time to be an advocate for your loved ones in these situations, but it's time well worth spending. And because you spend the time, your loved one is less likely to have these situations occur. Let's see, what else were we going to talk about? There's phony charities out there that call and try to solicit monies. Again, the telephone is a great way for non-family members to invade your loved one's home and wallet. So, you know, it's a fine line between having them have access to a phone and calling family and friends and not letting these unknown numbers get through, because there are, you know, a lot of fake charities out there that try to solicit money. There's a lot of these sweepstakes that are technically legal, but the premise of the sweepstake is the more money you spend on magazines and all these purchases, the more likely you're going to win this magical jackpot. So if you want to oversee a person's mail, have the mail forwarded to your house so that you're the one going through it to minimize some of these you know, a lot of these solicitations are solicitations. They're not requested. Oftentimes, if you do call, you can have them take a loved one off of a mailing list. You can put on a do not disturb, but be on top of that, because lotteries and sweepstakes tend to be a pretty popular scam that a lot of our seniors do fall vulnerable to, because they're at a stage in life where they want to win the jackpot because they want to give a legacy as big as possible to their family. So that is a scam that they're unfortunately more susceptible to. You've also got the home repair scam. So you always want to make sure that if anybody's coming into the house, it's somebody that you've vetted You wanted to make sure that these handyman and contractors are licensed and bonded. You don't want to just let anybody into the house to repair something. You want to make sure that whatever they're trying to repair needs to be repaired. You've also got people that dress up in phony law enforcement uniforms. They dress up in phony cable uniforms, phone uniforms, and they try to gain access to the house. I had a client here in La Jolla who, when her husband died, they published an obituary, and there were a couple of kids in Orange County that were looking at the obituaries, and they were going to the homes of these widows in La Jolla and Rancho Santa Fe. And what they did to this poor woman, who was at the time 89 years old, lived by herself, they went outside of her bedroom door and made a sound like a wounded dog. So she turns on the light, opens her bedroom door, which was a sliding glass door that went to the outside area. They put a bag over her head, they gagged her, and they basically tied her to a chair while they looted her house. Unbelievable. But luckily, she was able to give a description of these kids, and the police ended up catching them. And that was in the news probably 4 years ago. So you also want to be careful with, I mean, it's really sad that we live in this world, but it was an obituary about her deceased husband. That's how these kids up in Orange County found her in La Jolla, and that's how they were able to rob her. But luckily they were caught. But unfortunately, when you're that age, and she suffered some bruises, she ended up falling out of the chair. They weren't very gentle with her. She had bruises all over her body, and it took her a really long time to recover. So, obituaries are important, but anytime you make any information public, you want to be wary. And, if you're publishing information and a person who is a predator pretty much can read through the lines and know that there's a wealthy person who's now living alone, who's of an age that's more vulnerable, maybe it's not worth making that public information. So people ask me if you have to publish an obituary. Obviously, that's not a legal requirement. And based on these predators and elder abuse, to me, it's kind of a cost benefit analysis. If it were me, I wouldn't publish one, but that's just me. I think that's pretty much all the scams that I was going to talk about. Like I said, there's two forms of elder abuse. There's financial and emotional. Since we're an estate planning firm, we tend to deal with more of the financial side of elder abuse. If there is emotional elder abuse, which also involves physical abuse, you can report that to the district attorney's office. Adult Protective Services, you can always contact. When you call Adult Protective Services, you can request that you remain anonymous. If any of you want, Adult Protective Services does have a 24-hour hotline. They have an 800 number, which is 1-800-339-4661. You can also call the San Diego Police Department to report elder abuse. They take these cases very seriously. And you also have the San Diego County District Attorney's Office. And they are more than happy to investigate, especially the emotional and physical abuse claims, not necessarily always the financial ones. But that's pretty much what I wanted to talk about in a nutshell. Do you guys have any questions? I wasn't really paying attention to the chat. Is there any?
Hi, Heidi. That was an incredible presentation. So much information there. It's pretty depressing that this kind of stuff is going on at that level. So much of it, it's really horrible. But, you gave us lots of great tips. So I'd like to open it up. Members, if you have a question, please feel free to unmute yourself and just ask it.
And I just posted my phone number and email in the chat. So if any of you have any questions that you'd rather discuss privately, please feel free to call or email me. As I mentioned, I'm more experienced on the financial side of this. Unfortunately, I wish I wasn't experienced at all. I wish this wasn't even occurring. But if you have questions about, emotional abuse or physical abuse, you might want to call the Adult Protective Services line. Are there any questions? As Suzanne mentioned, does anybody want to unmute themselves and ask anything?
No. Okay, seeing none, we will go ahead Thank you very, very much for this. You permit us to post this, I know, on our YouTube channel, right? Because
Yes.
unfortunately, at this same time today was one of our open enrollment seminars. And that date was announced later. You know, we'd already scheduled you. So unfortunately, you know, some people will have to pick this up on the YouTube channel. But thank you very, very much for providing all of this great information, and hopefully
Suzanne,
it will help people stay. Yes,
Suzanne, it's Ron. I had a quick question.
please go
So-
ahead.
So I missed I'm going to go back and look at it, but your talk on fiduciaries.
Uh-huh.
A lot of us who are single without families in town, that's a possible solution for us to get them involved in our estate. But could you talk a little bit about how you can protect? I mean, that unfortunately there are instances of professional fiduciaries not doing the right thing also. So,
Sure. So I think when it comes to picking a private fiduciary, the most important thing to do is to ask for word of mouth for the names and numbers of people that other people you know and trust have used and recommended. We have a list here at our office of private fiduciaries that our firm and our clients have used and worked with and recommended. We did have a situation where one of our clients called with some negative feedback about one of the fiduciaries, and we immediately removed their name from our list. So I think, you know, basically word of mouth for any kind of a professional is always the best way to find people. A lot of people don't realize that a lot of these websites, even the San Diego County Bar, if you call the San Diego County Bar and ask for a recommendation or a referral to an attorney, attorneys pay to be on that referral list. So a lot of referral lists are things that people pay to get on, which is really unfortunate. So word of mouth is always my recommendation. And then once you have the recommendations and the referrals, it's really important to take the time to go and interview these individuals. Have a list of questions already prepared so that you don't walk out of there thinking, oh, I wish I would have asked this, that, or the other. So make sure that you're prepared for that face-to-face meeting, because it is like an interview. You're going to want to ask them what their process is. You might want to ask them specific questions about how they would handle certain situations. How much do they charge? What their fees are? What information from you do they need? Do they need a key to your house? Do they need copies of your legal documents? Do they need your financial information now, or how do they access that when the time comes? So those are really important conversations to have. And the nice thing about your legal documents and your estate plan is you should be updating and reviewing them. And as you update and review your estate plan, I would encourage you to reach back out to the people that you've nominated if you have professional fiduciaries in place, because you're going to want to reconnect with those individuals every couple of years. Because I know there was a private fiduciary here in town who was highly respected, and unfortunately she died suddenly this past year, and she's on a lot of people's documents, and she was in her early 60s. So her sudden passing was very unexpected. So always make sure that you're staying in touch with these individuals on a pretty regular basis, at least once every 5, maybe once every 10 years, just to make sure that they're still around and, you know, that they're still offering those services. It's always a good idea too to have a first, second, and third choice, because if the first person you did name did predecease you, or if they were no longer a fiduciary, or if they were incapacitated, you want to make sure that your documents anticipate that possibility and have a second person identified that could step in and take over.
okay.
We can assume that you're updating your list of recommended fiduciaries every year, so anybody could just reach out to you and get the most current list, right?
Absolutely. We always review it. We always reach out to our people. We make sure that they're still accepting clients, because the last thing I want to do is give somebody a list of a bunch of people that aren't doing it anymore. But yeah,
Right.
I do try to take my own advice with that and stay current with everybody.
But Heidi, I think you just what you said points to a potential problem with particularly single practice, single person fiduciaries is continuity. That's something
sure.
I worry about, even though somebody may be really good, that you have these situations where somebody suddenly becomes ill and can't perform their duties or passes away. So, that I understand that having you know, a the list of contingent people, I'm doing that too, but that's my general concern about a single practitioner, even though they're good, that I worry about something suddenly happening.
Yeah, that's a valid concern. I know that there is a group in town called Pro Fiduciary, and one of the things I like about that group is it is a group of multiple fiduciaries, so that if one of them became incapacitated or got sick, they have an office full of private fiduciaries that have access to the files, that can step in and take over. So sometimes it is better to have a fiduciary who's with a corporation and other group of private fiduciaries versus naming just a sole practitioner by themselves individually.
But
Okay.
can you speak to what happens, Heidi, if we name a fiduciary, say they're 50? I mean, even a young one, they can have a car accident or whatever and then not be there tomorrow. Do we name a second fiduciary in the trust documents? Or do we say at that point, contact Heidi for the next best person?
So you would want your document to identify your second choice, because what happens is let's say I'm a private fiduciary and you pick me first, but I'm hit and killed by a drunk driver, so I'm no longer an option. That's where if you pick somebody who's no longer alive, that nomination is automatically null and void. So that's where it's good to have a second person and third person listed. I know that at one point, I see a lot of documents where attorneys will give themselves the right to pick a private fiduciary. And that's how a lot of attorneys would deal with this very situation of making sure there was always somebody in place so the attorney or the attorney's firm could choose that private fiduciary. But now you're seeing that less and less in these documents, because if an attorney nominates a private fiduciary, and if they steal from you or if they do something wrong, you're going to sue the attorney, which you should, who recommended that fiduciary. So now you see that less and less in estate planning documents, where attorneys don't want the power to name a private fiduciary. So what I have in my documents is I say in my trust that if the people that the person listed aren't able and willing to act, then I give any of the people that the person nominated the ability to choose a successor trustee. But if all the people nominated decline or are unable to nominate a trustee, then my default is by a majority vote, the beneficiaries of the trust can pick a trustee. And to me, that's the best way of dealing with that situation, because why not have the very people, the beneficiaries, pick the person that's going to be helping them and dealing with them? So that's our default clause in our documents. If all the people named can't act and if they can't appoint, then the beneficiaries by majority vote appoint. And if we still don't have somebody in place, then our documents have the court appointing, which is a pretty standard default in most estate planning documents.
Okay, great. Can you rev up and go back to when you were talking about capacity? You mentioned that it takes one doctor saying that the person lacks capacity, and then other things come into play. Is it just one physician, or does it have to be two?
So it depends on how your documents are written. So when we write our documents say that if a person's primary physician makes the diagnosis, only that physician's diagnosis is needed. But if your primary physician who has the relationship with you and knows you is not available or not able to make the diagnosis, then our documents require two separate physicians that aren't related to you by blood or marriage to make that diagnosis.
Great. That's what I was wondering, because I was thinking otherwise a kid could just, go to a doctor who's not so straight and, say the person doesn't have capacity. Okay.
Yeah. And that's why I include the contingency that the doctor making the diagnosis can't be related to you by blood or marriage, because you also don't want that distant uncle who's kind of a fly by night to just arbitrarily say, yeah, she lacks capacity, when that's not even what they do on a day-to-day basis, is make that medical determination.
Perfect. All right. Again, thanks so much. Members, last shot. Any other questions? All right. Otherwise, if they're all joining me in thanking you again, Heidi, we have your permission to post this, of course.
Absolutely.
All right. Thank you so very much, Heidi, and have a great day. Take care.
Thank you guys too. Bye-bye.
Bye.